McDowall. Good morning, good morning, good morning, good morning, good morning. My people, my people, my people, my people. My name is Alan Palmer, St. Vincent the Grenadines' favorite and most hated son, the diaspora machismo. I am coming to you this morning to talk about a possible miscarriage of justice that is being perpetrated upon the people of St. Vincent the Grenadines by the dishonest Prime Minister, aka Ralph Gonsalves, aka Shit Stain. And he is using the Director of Public Prosecution, Sejilla Mc Dowall, to cause a possible miscarriage of justice to ensure that Ashell Morgan and Margan and Nelson walk free. I am going to bring this to your attention. I'm going to tell you what exactly she is doing and she have done that is in contrary to the law of St. Vincent the Grenadines, and that it may possibly cause a miscarriage of justice in the Cornelius John case. People, I'm not going to stay long. I'm going to try to be brief. I'm going to say what I have to say. I'm going to leave here. But if you remember, when I first bring this thing to your attention, right? When I first start dealing with this matter, I declare to the public that I know Ashell Morgan personally. I tell you that I know Ashell Morgan since she was a little girl, right? Going to prep school. I also tell you that I was fond of this little child, right? And I knew her when she was going to girls' high school. And I always kept in touch with her mom. And her mom will brief me as to what Ashell was up to. So even though I had close relationship with Ashell as a child, right? It does not mean that I think that Ashell Morgan is above the law. Let me make this disclaimer here. It hurts my heart to see that someone who you admired and loved as a child, right, have taken a turn for the worse. But therefore, I conclude that Ashell Morgan and Margan Nelson, though I am probably close to Ashell, is not above the law. And she should experience the full extent of the law for the crimes that she was a part of. I would also let you know that I think that Mr. Cornelius John B. treatment is fitting for him. Why? Because Mr. Cornelius John aided and abetted and encouraged and enabled the commission of crime against many citizens of St. Vincent the Grenadines. And not only did he participate in showing support for the criminal activities of Ralph Gonsalves against people like Michelle Andrews when he attended the rape rally and transported people in support of Ralph Gonsalves and made serious allegation of rape and sexual assault against a citizen of St. Vincent and the Grenadines. He also transported people to that rally, even in the light that Ralph Gonsalves would have confessed to the crime, to the serious sexual offense of sexual assault. So I think that the way they are now treating Cornelius John is fitting for his support of Ralph Gonsalves. Let me tell you something, people. I wanted to share the video because the haters of justice have already dispatched their slaves with transmitters on their person to try to hamper this video. So it is important that you share this video. So in your sharing it, it will go far and wide. Leave your comment. Show me that you like what I say. I want you to support this video by sharing it. Right, people? And when you share it, Cathy Clem has shared. Let me know that you share it so I can big you up. In the same way, I just big up my woman, Charmin Bailey. Right? Cathy Clem, who have just shared this video. And let us get in to the matter here now. Let us get into the matter here now. Let me show you how Holy Love, my sweetheart, nice to have you. Share this video. Let me show you how the Director of Public Prosecution, Sejilla Mc Dowall, is trying to cause a miscarriage of justice in the way she is dealing with this matter, right? And let me tell you what we're going to accomplish in this video. I'm going to tell you the effort. I'm going to tell you case strategy in dealing with this matter, because I've been following Kay long enough to understand the way she operates. Holy Love, share. Thank you very much. To understand the way she operates in her investigation, in her initial court proceedings, and the way she go about trying her matter. I'm going to tell you what is her strategy in dealing with this case, and she has a strong strategy. I'm going to show you, right, the DPP McDowall efforts to cause a miscarriage of justice. I'm going to explain to you what joint enterprise we have been hearing Kay speaking about joint enterprise since this case began. I'm going to tell you what is meant by joint enterprise, and I'm going to show you why Kay is right in calling for charges of joint enterprise in their respective capacity to be preferred upon Ashell Morgan and Karim Nelson, right? So let us begin. Let me tell the people, right? I don't know if you're going to share this video or not, but the powers that we don't want you to learn these things, especially the members of Rise Haruna, they don't want you all to learn these things, because they are hoping that after Ashell Morgan and Karim Nelson were charged and taken before the court, that you will be satisfied and contented, that you go back to your various homes, and that you would allow a miscarriage of justice to take place. If you don't share this video, then the message will be limited in its reach and its scope, and it would allow Ralph Shit Stain and Sejilla Mc Dowall to cause a miscarriage of justice, and therefore all of your efforts, all of your Facebook purge, all of your lobbying, all of your protesting would have been in vain. So people, I am encouraging you to share this video so that the message can reach in the quarters it's supposed to reach, right? And I will be happy when I see you share. Now, a lot of you know who the third person is. I know who the third person is. And you are wondering why Kay Bacchus, in her capacity as lawyer for Cornelius John, don't know who the third person is. It is not that Kay Bacchus don't know who the third person is. It's the fact that she, being an experienced trial lawyer and a professional in the capacity of mitigating cases in the Court of Laws in St. Vincent and the Grenadines, have to follow the law. And I will tell you why she have to follow the law, and why she have to get the name of the third person from an official source, right? I will tell you why it is important that she get the name of the third person, a name who I know, a name who you know, from an official source, right? Now, first thing, it is important that Kay get the name of the third person from both Ashell Morgan and Karim Nelson. It is very important. Why? To show the community that when you participate in criminal activities with people who you think can protect you, they actually cannot protect you. Because the law will ensure that Ashell Morgan and Karim Nelson snitch on the third person bring the name of the third person to board. K is asking why charges are not preferred upon the third person. It is not really K's intention or desired for charges to be preferred on the third person. But she have to do her job as a lawyer in order to show the seriousness of the offense. This is what K is going to do. And from following the way she operates in court, I know how she operates. I know her techniques. I know how she approaches her cases. K is going to use the disclosure or the discovery process to find out who the name of the third person is from Kareem Nelson and from Ashell Morgan. And in the disclosure proceedings, they are compelled to, they have a lawful obligation to disclose the name of this third person. In other words, the laws of St. Vincent and the Grenadines is going to make sure Ashell and Kareem snitch on the third person who they don't want to come out here. Right? In California, it is called criminal disclosure. And in the criminal disclosure proceedings, you can do what is called interrogatories, right? You can do a deposition. You can ask for them to submit documents, and they have to submit it, because all of this is in the discovery law or the disclosure law of St. Vincent and the Grenadines. Interrogatories are written questions that are submitted for written answers. In the same way, when Donald Trump was being impeached, the Democrats sent, the State Department sent interrogatories to Donald Trump, written questions, and they solicited written answers, which he must give on the penalty of perjury. So if he lied, he can be taken to court for perjury. And this is what K is waiting for, to ensure that the nations know that if you are going to be an accomplice in any crime with any person in authority who you think is able to protect you, they cannot protect you. Ezekiel Simmons, blessings to you. Share the video. They cannot protect you, right? Let me tell you what K is going to do with the information. When she gets it up about the third person, K is going to apply to the court for a subpoena and subpoena the third person to court to give evidence as to what he sees, what he saw, and what transpired at the scene of the crime. So therefore, the man who they take to support them, to help them, is going to now give evidence against them in court. Right? And he cannot, once a subpoena is issued for his appearance in court, he have to present himself. He have to answer the questions truthfully. And if he don't answer the question truthfully, K has the authority to now ask the court to have him charged with perjury in the same way they did Burnett Fredericks. And she can now treat him as a hostile witness, where she can forward question to him in a manner that is not friendly as an examination. Right? And let me tell you the question that K is going to ask. What was the discussion yourself, Ashell Morgan, and Kareem Nelson had prior to you going on the mission that resulted in the injury of Mr. John? Did you understand the full intent of your role in going there? What was the discussion you had when you were on your way to Mr. John's house? Right? The main reason why did you went to Mr. John's house? What was the group's intention of going to Mr. John's house? It is believed that this young man has some little authority behind him too, in the course of a police officer. They send new people. They send new people. Right? So you have to find out in what capacity did the third person go to the scene. Did he go there in the capacity of a police officer, or just as a friend accompanying these people to deal with a dispute? You have to tell the court what happened on Mr. John's premises in detail. You have to also share with the court how he felt about the events as they transpired on Mr. John's property. What did he do to stop the events, if anything, and if he didn't do anything, why he didn't act to stop the abuse and the shooting of Mr. John? These are pertinent questions that this third person have to answer. What is the discussion and the nature of the discussion and what was said while the third person, Karim Nelson and Ashell Morgan, left the John's premises and was on their way to where they went next? Why didn't he come forward when K. Bacchus, as counsel for Mr. John, was trying to find out who the third person is? It is important that you find out this, because you may just find out that Ashell Morgan and Karim Nelson and probably Shit Stain would have encouraged this guy to stay quiet and don't come forward, in contrary to the laws of St. Vincent and the Grenadines. So this is one of K's approach in getting the information from those two suspect or perpetrators. Let them snitch on their help, and so we can show the community that if you are going to be involved in criminal activities with people who you think can protect you, that they really cannot protect you. People share the video, right? They really cannot protect you. It will be interesting to know that if Ashell Morgan and Karim Nelson was cautioned as it relates to the injury that they inflicted upon Mr. John. Let me tell you why it is important to know. If they refuse to be cautioned, and if they refuse to answer any questions as it relates to the injuries they inflicted on Mr. John, then Mr. John's witness statement and the witness statement of the people who were there must be accepted by the Director of Public Prosecution in its entirety. Thank you for your honor, my sweetheart. As being truth without any discrepancies. The Director of Public Prosecution will be amiss to use the witness statement of Karim Nelson and Ashell Morgan in order to prefer charges, the charges that they brought against them. You cannot use their witness statement. That statement was not given in the capacity of a defendant. So it would be a miss of the Director of Public Prosecution to use their witness statement against Mr. John as to determine the nature of the charges that were preferred upon Karim Nelson and Ashell Morgan. If they want a particular charge, they have an obligation to be cautioned and to present their side of the story to the investigators. That is their obligation to their defense. You understand? So if they refuse to be cautioned, if they refuse to answer questions as a defendant, then the Director of Public Prosecution and the investigators have to take Mr. John's complaint in its entirety as the truth, the whole truth, and nothing but the truth, and base all charges against Karim Nelson and Ashell Morgan based on Mr. John's statement. They send security. Tell them kiss my ass. I don't care about them. Now, so that is one thing. Let me show you the DPP's effort. Let me show you the DPP's effort to cause a miscarriage of justice. And I'm going to speak it in simple, plain, and understandable language. So even the simplest among us, who does not have any legal training or have not been entangled with the law and may not fully understand the legal entanglement, would understand. When you're going to charge a person, right, there is 3 facets that you need to have coming together to form or create a sound charge. The first one is the actions of the defendant, right? The actions of the defendant. The second one, if there were injuries, the medical records. So you have the actions of the defendants, their intent, the medical records, which would outline the nature and the degree of the injuries that were sustained. And the third one is the law under which the person is being charged. These 3 ingredients must come together and they must harmonize and be supported. Listen to me carefully, people. The Director of Public Prosecution, a trained lawyer, a trained and practicing lawyer, preferred the charges against Karim Nelson of wounding. All the other fancy thing is just thing, basically wounding. Right? But before these charges were preferred, there were allegations that Mr. John's medical records was missing from the hospital. It is only after the charge had been preferred that the news came from hospital administrator that the records were not misplaced and the records are accounted for. So the question we have to ask here, as civilized human beings, the police officers, Kenneth John, how are you, who investigated the matter, during their investigation, did they have access to Mr. John's medical record? Because it will make a difference whether they had access to Mr. John's medical records or not. And I will tie it all in. It is also important to ask, since the records went missing prior to the Director of Public Prosecution preferring the charges of wounding upon Karim Nelson, did they had access to the medical records of Mr. John? Because it is important that they had access to formulate the charges. And let me tell you why. Remember I say three things must come together. The actions of the defendant, the injuries the complainant received, and the charges, the section of law that is being used to prefer the charges upon the defendants, right? Here we see that Mr. John, who has been injured, has been wearing a cast on his leg for several weeks now. A cast that is prescribed by a doctor is to deal with one of two problems. It is either Mr. John sustained a broken bone and he need his leg to be reinforced and stabilized to aid in the proper healing of the broken bone, or two, the injuries that Mr. John sustained damage nerves in his legs, and therefore he need to wear a cast to keep it in place so that the nerve can heal as they were before they were injured. And the crutches that he was prescribed, remember, a crutch is a prescription also. The fact that the doctor prescribed Mr. John use a crutch is because he does not see it fit to cause Mr. John to put weight on the injuries that will hamper the proper healing of the injuries. So here we see, and according to Mr. John's lawyer, K. Bacchus Brown, the initial diagnosis of the doctor when Mr. John was treated is that Mr. John have suffered a broken femur, which was broken because of the bullet he received, the gunshot wound he received. Therefore, here we see a situation here. Broken bones, nerves damages, takes the charge out of wounding and into the territory of previous bodily harm. So now here we see here, we have a situation where the actions, the injury, and the charge under which the defendant Karim Nelson was charged does not harmonize. So here we see Karim Nelson, if he was charged without the medical records, his matter will be dismissed on a technicality because the charges does not harmonize with the injury Mr. John sustained. The injury that resulted in a broken bones take the charges out of the scope of wounding into the scope of previous bodily harm, because wounding only is classified that you have a laceration. That's all it says. The injury resulted in you getting a laceration, meaning the tearing of the dermis, the epidermis, and some muscle tissues. When you have broken bones and damaged nerve tissues, it takes it into another scope, into the scope of previous bodily harm. Even Ralph Gonsalves could go to court with his lack of training and ask the judge or the magistrate for this matter to be dismissed on a technicality of the inappropriate charge and the inappropriate law that is used, because the law and the injuries does not harmonize. So you see how they are playing with Vincentians. They cause the record to go away, the medical records to be disappeared, so that they can perform the wrong charge upon Karim Nelson. So any fool who has a little understanding of law can go into the court and ask for this matter to be dismissed, because according to the medical records and the laws, right, the charges are inappropriate. Case closed. Matter dismissed, the serious offense gone away. Let us go to Ashell Morgan. And you see, Kenton Chance is a hypocrite. You read Kenton Chance's articles, and he is intentionally leaving out important points, because he wants the public to think that it's just ordinary threats and ordinary assault. But the fact that the Director of Public Prosecution charged Ashell Morgan for assault, right, with the intent to cause wounding. She didn't charge her with assault with a deadly weapon, but just an assault with the intent to commit to it wounding. Shows that she also trying to get the charge kicked out of the courts. Let us examine Ashell Morgan's behavior and her words that was used to come up with the charges for Ashell Morgan. What she did after Mr. John was shot and was helpless, she put a firearm in Mr. John's face and threatened to shoot him in his mouth if he calls her name. The calling name thing, I'm going to deal with that in another issue. So therefore, she assaulted him with a deadly weapon. Secondly, her threats was not intended to cause wounding, but it was intended to cause murder. Because if you put a gun to a man's face and threaten to shoot him in his mouth or in his head, there is more likely a case that from a gunshot wound to his mouth or to his head, because remember his mouth is on his head, is going to result in the death or the murder of Mr. John. Another false charge that any silly lawyer can go into court and call for dismissal of. Right? This is just a fact. People, this is just a fact. Remember I told you that a charge, there must be harmony in the actions, which in this case, the pulling of the gun and the uttering of the words. There must be harmony in the injury, if any occur. But there was no injury in this case. And there must be harmony in the law. So here we see a lack of harmony in the law and the actions. So therefore, it is a perfect recipe for the dismissal of this case again. So we see that the Director of Public Prosecution is trying hard to ensure that our friends and our colleagues, get off scot-free. Mr. John's injury does not constitute wounding. It constitutes previous bodily harm. It should have been not a summary offense, but it should have been indictable. And these cases should have gone before the court, before the High Court, before a judge and a jury. But Ashell Morgan is a strong-willed person. You see, I personally believe that Ralph raped Ashell Morgan. And because Ashell Morgan is strong-willed and a confident woman, she is going to milk the system to keep quiet. And it is in Ralph interest, Shit Stain's interest for Ralph Ashell Morgan not to speak about her sexual victimization at the hands of Ralph Gonsalves. Because if she does that, all hell break loose in St. Vincent and the Grenadines. All hell break loose in the diaspora. Because Mia Motley, as a woman, will not let this pass. Although she's gay and she loves girls, she will not let this pass as a woman. Our three major and zero, Dr. from the University of the West Indies, they will not let this pass. Rowley in Trinidad will not let this pass. Kamala in Trinidad, the opposition leader, will not let this pass. So it is in his interest to let this thing die a natural death, so that Ashell will remain quiet and monopolize the system for her benefit and not speak about her victimization at Ralph's hands, at Shit Stain hands. It is important for them. Some of you don't want to hear this, but you all have to take it because it is the truth. Take it because it is the truth. And don't worry, I'm going to speak about that English lawyer and why she was why they're trying to force her to St. Vincent and the Grenadines. There is more in the matter beside the pistol, but that is for another day. That is for another day. The slaves are coming into the park with their phones in their hands, with their intention to interrupt. But people, if you share this video, it will reach in the quarters. It is supposed to reach. You understand? Don't let them stop it. Don't let them stop the truth. Right? The slaves will do their work. And you must do your work by sharing this video. Let every Vincentian know what is happening. Now, the police have declared Ashell Morgan is not a licensed firearm holder. But the DPP had saw enough evidence to prefer a charge of assault with the intent to commit wounding. That means there was enough evidence for her to believe that Ashell Morgan had a firearm, as was alleged by Cornelius John, the complainant, at his home, and that Ashell Morgan used that firearm to assault him and to issue deadly threat against him. That is why she preferred the charge of assault with intent to commit wounding. Because if she only assaulted him, then it was not with intent to commit wounding. It was just an assault. But the fact that the evidence would have shown that Ashell, enough evidence would have been borne out that Ashell had a firearm, and since she's not a firearm holder, why isn't she being charged with possession of an unlawful firearm without the prerequisite license to carry such? Why is it she's not being charged with that charge? Why is it? Huh? People, sense make before book. If you can charge her with assault to commit wounding, that means she had a weapon. And the weapon that was alleged is a gun. And if she's not a licensed firearm holder, she has no right to have a gun in her possession. And if she used Karim Nelson's gun, that is grounds enough for charge her for having in her possession an unlawful firearm without a prerequisite license. And if she used Karim Nelson's gun, it means that that is grounds for Karim Nelson to be stripped of his licensed firearm. People, come on, think. That is why the youths cannot sit on their backside, but the youths have to become more active and be vigilant to ensure that justice is being done. Right? That justice is being done. Now, let me teach you. When you hear Kibakis is talking about Ashell Morgan and Karim Nelson, and in some cases you will say the third person should be charged with a joint enterprise. What is KP speaking about? All K is saying that the crimes that was inflicted upon her client, Cornelius John, was not done in isolation. Right? It was a group effort. So in joint enterprises, she's saying that Ashell Morgan, Karim Nelson, and the third person should be charged jointly, either as conspirators and co-conspirators, or as one aided and abetting the commission of the crime. So if Karim Nelson is being charged with the wounding of Mr. John, it means that Ashell Morgan should also be charged as aiding and abetting the wounding of Mr. John, which carries the same penalty as the wounding itself. Or she must be charged as a co-conspirator, meaning that she conspired with Karim Nelson to commit the offense. Right? And I will bring to you some case laws that will justify this. Case laws that will justify this. For you who don't know, a case law is when a high court make a decision, right? And the principles of the decision become the principle that every law court should follow. For example, if the appeal court, the Eastern Caribbean Supreme Appeal Court, make a decision, the principle on which it makes the decision, anytime the magistrate court and the Supreme Court have those same principle in a matter, they are compelled and they have to follow the same principle that was laid down from the appeal court. That is what case laws is. The decision of the case now becomes a law that the other courts have to follow. Now, in conspiracy, right? In the case Osa versus George, that is volume 252, the California Appeal, the second division, 660 to 667. This is what it says. This is what it says. It is not essential or necessary that there be an agreement as may be implied in the word conspiracy, but it is essential that each particular defendant charged with the responsibility proceed to commit a crime. The action was to commit a crime. That is, with the intent to do so, right? So, when we hear conspiracy, we think that the two people have to get together and say, hey, 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 let's do this. No. Once you go to a place and it is your intent to commit a crime, once the crime was committed, even though you didn't discuss it beforehand, it is conspiracy. It is not necessary for agreement, for prior agreement to be necessary, right? Let me tell you this other one here. Peoples versus Fitzwater, volume 260, California Appeal, the 2nd Division, page 478. Each with specific intent to commit an unlawful act or an overt act to the agreement. So if they have an intent to go there to commit an unlawful act, right, and the act was committed, it is conspiracy. So we have joint enterprises, right? So they commit the act and they try to cover it up. We have joint enterprises, and this is what they did when they leave the scene of Mr. John's residence. It was their intention that they would not be discovered. So they commit the crimes and they try to avoid being discovered. They were overt in their behavior. And in Peoples versus Black, volume 45, California Appeal, the 2nd Division, page 87, the risk of conspiracy to commit a crime is the unlawful agreement to commit a crime, accompanied by an overt act in the furtherance of such agreement. That means they will hide it to ensure that they are not discovered. And listen to this one. This is Max Incorporated versus Woods, volume 202, the California Appeal, page 675. Listen to this. The act of one during a conspiracy is the act of all done in the furtherance of the conspiracy. So even if both of us conspire, right, we don't have to come to an agreement beforehand. But once we go to the scene, and whatever I do, whatever Karim Nelson did, Ashell Morgan, Rosden Good and Goody have to carry the blame for it. Whatever Ashell Morgan do, Karim Nelson has to carry the blame for it. The act of one in the conspiracy is the act of all. So that is why you hear K is crying for joint enterprise. Joint enterprise. They must be charged with conspiracy. And they must be charged with aiding and abetting. So therefore, Karim Nelson should have 3 charges. Right? Ashell Morgan should have 3 charges also. Everything that Karim Nelson is charged with, Ashell Morgan must be charged with as a co-conspirator, which carries the same penalty as that of which the actual action is called. And every charge that is preferred upon Ashell Morgan must also be preferred upon Karim Nelson as a co-conspirator, or as one who aided and abetted the charges, the actions against Mr. John. People, they are trying to cause a miscarriage of justice. It will be interesting to see how much people have shared this video. It will be interesting to see, right, if we are going to sit back and not share this video and allow a miscarriage of justice to happen right before our eyes. After all the big talks on Facebook, after all the protests, after all those people who you never see spoken before is coming out and speaking, hey, we never used to have no Zingahan say live in St. Vincent the Grenadines. Zingahan has been living a private life. People probably only see her slipping back and forth from her office to her home. But when you see a private woman like Zingahan, right? She was always a private person. Even when she's going to primary and secondary school, you only see her moving back and forth. Hardly seeing her speaking with anyone. When you see Zingahan and them have to come out and write articles, you must know. So are you going to sit back and allow all of this, all of the protests, all of the social media activism, all of the talk shows that discuss this? Or are you going to let them walk away free by not sharing this video so everybody could be informed? I know some of you want to go back and do your own little video and present this information like if it is yours. That is quite okay. Do that. Do that. You don't have to give me no credit. But do your part in sharing the video also. Do your part in sharing the video, people. My name is Alan Palmerson, Vincent the Grenadines' favorite and most hated son. I think I see Monica Findlay, Faye. Okay, second, but if he still have fragment in his leg. Yeah, Faye, you're correct, you're correct. I can't really read it properly, but I get the gist of what you're saying, right? And I'm sorry that I'm unable to read it because I'm facing the sun. And these people are, you know, they have already sent their people out to try to interfere with the video. But people, it's all up to you. I've given you all of the information that I have collected so far. And I'm going to tell you something about that British lawyer who the St. Vincent and Grenadines government tried to deport unlawfully, even after the lady has submitted to the relevant authorities a notice of appeal, which is her right to do in a deportation order. Right? They try to still deport the authority. There is more in the matter beside the pistol. I'm going to bring that to you later this week. But for now, let us thank the Most High for the knowledge, the understanding, and the wisdom that He has bestowed upon me. And let us thank the Most High for giving me the opportunity to share this knowledge, this understanding, and this wisdom with the people who I love the most. The Vincentians all over the diaspora, Caribbean people, my people, people of the Israelite descendants. I am gone.